Hello and welcome everybody to our event today on the ending the overnight detention of children in police custody. As you can see, I am not Baroness Zeta, I am Louise King and I'm Director of Policy and Campaigns at Just for Kids Law. Unfortunately, Baroness Zeta has been called away on urgent parliamentary business, so is unable to attend today. So I'm going to be chairing in her place. Baroness Zeta is really disappointing that she couldn't join this event, as she sees the issue of overnight detention of children in police custody is really important. And even though she can't be here today, she said that she will definitely be continuing to work with us on this issue going forward. And she really passes on her sincere apologies that she's not able to chair this event as initially promised. So before we get started, I'm just going to do a little bit of housekeeping. Firstly, if you've got any technical problems, please can you contact my colleague Lily Bayrock. She's put her, sorry, I've just got a message saying someone can't hear me, and I'm just checking everyone else can hear me. So if I don't get any messages, I'm assuming that I can. But I will turn up. Okay, some people are saying I can. I will turn up my volume a little bit just to make sure that Tim can hear me. So sorry, I was just saying a little bit of housekeeping before we get started. If you've got any technical problems, please contact my colleague Lily Bayrock. She's putting her email in the chat, so you can contact her directly. Also, keep an eye out for Lily's messages in the chats, which will include the link to our new briefing and further technical information. For the Q&A section, which we're going to be having a bit later on, we'll be using the Q&A function in Teams webinar rather than meeting chat. This can be found at the top of the screen, and it's got two speech bubbles with little question marks in it and Q&As. So we will be using that rather than the chat, but I will remind everyone before we get to that part of the agenda. So this event is part of Just for Kids Law's ongoing work to highlight and eliminate racial disproportionality in the youth justice system, which also includes reducing the number of Black and minority ethnic children being held overnight in police detention. And it builds on our strategic litigation in this area, which was led by my colleague Jennifer Twite, who's taken a number of legal challenges where children have not been provided with local authority accommodation post-charge. So at this event today, we're going to hear from a number of experts on this issue and discuss what more needs to be done to ensure that children are treated expeditiously and as a priority at the police station. But before we hear from our speakers today, I just wanted to give a bit of a background to my organisation, Just for Kids Law. So for those who may not know, Just for Kids Law was set up in 2015, and our mission is to ensure that children and young people have their legal rights and entitlements respected and promoted, and their voices heard and valued. And we do this through a number of ways. We provide a direct advocacy service to children and young people to ensure that their voices are heard in key decisions affecting their lives. We also provide legal advice and representation in a number of areas, including with children in contact with the criminal justice system. And we use the evidence from our direct work with children and young people to campaign for policy and practice change. We also host the Children's Rights Alliance for England, which monitors government implementation of the UN Convention on the Rights of the Child, which the UK ratified back in 1991. And it's within this child rights framework that our work on children in police detention takes place. The UN Convention on the Rights of the Child is clear that in all actions concerning children, their best interests should be a primary consideration. And it also stipulates that the detention should only be used as a matter of last resort and for the shortest possible time. And this applies to police custody as much as any form of detention. While there has been some positive developments in this area, some of which we will hear about later today, there's still much to do, and we do hope that this event will be a springboard for further action. So without further ado, I will shortly hand over to my colleague Augusta, who's been leading our work in this area, and she'll be talking about our recent research findings and our recommendations. So Augusta is our youth justice lawyer and policy officer at Just for Kids Law, and she works to effect nationwide systematic change in youth justice system through policy influencing and public affairs work. But Augusta splits her time between doing policy work and legal casework. She represents children and young people at the police station and at youth and adult magistrates courts, and she's also responsible for providing legally accurate information, advice and guidance on youth justice law and practice at our Youth Justice Legal Centre Free National Legal Advice Line. Augusta's been with us since 2016, and she previously worked at the charity Become and Advocates for International Development, and has done a number of volunteering work at legal clinics, including the Kent Law Clinic and the Free Representation Unit. So Augusta, over to you, and I'm looking forward to hearing the research and recommendations from this project.
Hi, everyone. I'm just going to share the PowerPoint slide in a minute. Brilliant. You should be able to see my presentation. So today I'm just going to give you a very brief overview of the work, some of our initial research finding. You will, however, be able to review our research findings as well as our recommendation in full by reading our briefing. Following on from some of the things that Lou just recently mentioned, I just wanted to quickly refer to some of the key legislations which highlight the need to avoid detaining children overnight unless absolutely necessary. More notoriously, the Children Act 2004, Section 10 and 11 place a statutory duty to have regard to the safety, welfare, and well-being of children. The language of the Children Act, as well as the United Nations Convention on the Rights of the Child, are also found in the National Strategy for Policing of Children and Young People, which is clear that in any interaction with children, any encounter, they should be treated as children first. Another key piece of legislation also an additional guidance is also found on PACE, specifically Code C, Para 1.1 does talk about dealing with children expeditiously. And similarly, the College of Policing Authorized Professional Practice does talk about prioritizing triaging vulnerable detainees as part of the booking process, and these also include children. Similarly, the National Strategy for Police Custody does refer to the fact that custody for children should only be used as a measure of last resort, again mirroring the language found on the United Nations Convention on the Rights of the Child. I will now move on to, following on from these key pieces of legislation I've just referred to, I will now move on to what are the overarching opportunities that we've identified for legal reform. And some of our top line recommendations include the need to have a right-based approach across every area of youth justice. And some of the ways to achieve this includes raising the age of criminal responsibility, as well as setting a much reduced time limit to how long children can be detained in custody, especially in custody overnight. Other key opportunities that we've identified as part of this research for legal reform include a change of the Police Crime and Evidence Act of PACE, specifically Section 38C, in order to include children who are arrested on warrant and those who are arrested for breach of bail in the protection afforded to those who are held overnight post-charge, because currently, unfortunately, they are excluded from the protection available under PACE. Quickly, just looking at what is the scale of the issue that we're talking about. As you can see from this graph, you will notice that each year, at least for the year 2019-2020, just to note that the Youth Justice Annual Statistic, which we have used to contrast our finding, does go from March 2019 to March 2020, whereas our data for that year does go to January 2019 to December 2019. But yet what you'll see is that of the 58,000, nearly 59,000 children who were arrested in that year, about a third of them, so just over 21,000, were held in police custody overnight. And you will see that this is only data for 34 out of 43 police forces. So this number is likely to be a significant underestimate, and it currently includes both pre-charge and post-charge detention. We have carried out FOI for the subsequent years. However, this remains one of our most comprehensive set of data available. When breaking down this information further by age, what becomes clear is that still a significant number of children, especially those under 15, but as well as those under 12 and as well as 9, under 10 years old, so that being below the age of criminal responsibility, are still being held overnight in police custody. The problem is still very significant. And whilst we have noticed a year-on-year decrease, reflective of the general decrease that there has been overall in the youth justice system, it is very clear that this is still a significant issue and one that needs urgent action to be taken. Similarly, when breaking down the data, it becomes clear that the number of Black children and also children from other ethnic groups who are overrepresented both in London and nationally is still disproportionate. Now, I just wanted to quickly have a look at some of the additional analysis that we've done in relation to our research findings. Unfortunately, this more detailed analysis was only available for 24 out of 43 forces, that being the number of forces who provided us with comprehensive enough data to do this breakdown. So by looking at the 15,000, roughly 15,000 number of children of all those police forces, we were able to observe that about 20% of them are held post-charge, whilst a significant, a vast majority of them, over 80%, are still held pre-charge. Of those who are held post-charge, roughly 50% of the time accommodation is then requested, whereas about 50% of the time, again, is not requested. And of those requests, and I think this is something, one of the most significant takeaway from this presentation is the fact that 52% of those requests, being only half of the requests of those who are held over a post-charge, are still for secure accommodation. And based on our understanding of this area of law and also of our casework around this area, we do feel that number should not be as high and should be much, much reduced, because most of the children will not meet the very high legal threshold for secure accommodation to be provided. And rather, what we believe is happening on the ground is that many requests for, many wrongful requests for secure accommodation are being made. Lastly, the last graph I just wanted to present to you before moving on to some of our key recommendations relates to the length of the detention period. So we did a more thorough analysis of one of the police forces who provide us with a more comprehensive set of data. So this data only relates to one police force. Again, the reason this has been done is because there is no comprehensive data from all police forces to be able to do an analysis of this level on a national or even regional scale. However, by looking at the data provided by this one police force between January and December 2021, what emerges is that the average detention period of the total number of children who were detained in the police force was 18 hours. And you will see from this graph that the day, not only with the highest number of children being detained, but with the number of children being detained for the longest period is Saturday. And one of the most obvious and logical conclusions to this is because these children, if arrested on Saturday, they have to wait until Monday to be taken to court with the first available court sitting date. Of all of these occasions of overnight detention, 12%, so to round up, over 10% of these are still of children who are being detained for a period exceeding 24 hours. So as well as the recommendations, the opportunities for legal reform, which we have identified earlier, some of our key recommendations for government include the review, to review the collection, collation, and publication of data, because what has become clear is that this is an issue that is still affecting many, many children, and we've just been able to gather the information relating to a very small number of children. So it is of utter importance that this information not only is collected, but also is made available. We would ask for this information to be made available as part of the annual youth justice statistics. Similarly, we have found that still a very small number of local authorities as well as police force are signatories to the Concordat, and one of the requests that we would have, one of the recommendations we have for the government is for there to be more proactive action to ensure that local authorities and police forces are signing up and are implementing the Concordat. We also consider that Her Majesty's Inspectorate of Constabulary and Fire and Rescue Services should carry out a thematic review looking at the overnight detention of children in police custody with a focus on race and ethnic disproportionality. Again, given the high number of children, especially from Black backgrounds, Black children who are still being held overnight in police custody. Other recommendations are more specific to bodies such as the National Police Chief Council and Chief Inspectors. And these come from just observing some of the data and also observing the lengthy detention periods and the days where children are more likely to be detained. And we feel that simply monitoring and reviewing arrest times, wrongful requests for secure accommodation, decisions to authorize police detention as well as continued detention, as well as decisions to refuse post-charge bail and prolonged detention period are all different aspects that, if monitored and reviewed, could make a huge difference in reducing this number. Equally, we would recommend that immediate practical steps are taken to ensure the children are not arrested outside of working hours, specifically during the weekend and between 5 p.m. and 9 a.m. The reason behind this is because, again, we've been able to observe that children who are detained outside of working hours tend to be those who are held for the longest period of time. We would also ask the College of Policing to provide specific guidance to the police as part of their authorized professional practice about their duties under Section 11 of the Children Act and how that duty interacts with the decisions on arrest and detention of a child at a police station. Lastly, one of the key recommendations that we would like to see implemented is from the Independent Office for Police Conduct to publish a learning the lesson on the overnight detention of children in police custody, as well as carry out a thematic review of cases concerning children, overnight detention of children, and again with a focus on race and ethnic disparity. Thank you very much for your time and for listening. I will now hand over to my colleague, Dr. Miranda Bevan. Thank you.
Thanks very much, Augusta, for that overview of our recent research and data. And also, I would just ask everybody to take a look at the briefing for our kind of full set of recommendations. So we're now going to hear from Dr. Miranda Bevan, who's a lecturer in law, specialising in criminal law and criminal justice at Goldsmiths at the University of London. And she's going to be talking about her latest research findings on the impact of police detention on children. And I think this is going to be really important in terms of setting a bit of we've had the overview in terms of the numbers and the statistics and how many children are affected. But I think Miranda's speech will also give us a bit more of an insight in terms of why this is such an important issue to address. So Miranda is a lecturer in law at Goldsmith, as I mentioned, and before moving into academia, she was practiced as a criminal barrister. And she also spent 2 years at the Law Commission as a lawyer with responsibility for the unfitness to plead report. And she's also worked as a policy associate at the Howard League for Penal Reform. Her research is focused on vulnerable suspects and defendants, police custody, and effective participation and unfitness to plead. Her doctoral research has explored the experiences of children and young people detained as suspects in the police station in England and in Wales, and her work broke new ground as the first substantial empirical study in England and Wales focusing on the child's perspective of police detention. And that's why we're so interested and really pleased that you're here today, Miranda, to hear what you have to say on this topic. So over to you. Thank you.
Fantastic. I'm just going to share my screen. Sorry if I did that prematurely. Can you all see some slides? All good?
Yep, we can definitely hear that.
Brilliant, that's fantastic. So thank you so much for having me today. So I want to talk a little about a research project that the fieldwork for which was in 2016, 2017, and I've been continuing to write and think about children in police custody since that time. So the study talked to children and young people with experience of police custody in England and Wales. I spent time in 3 force areas observing custody processes for children, and I interviewed a range of different practitioners, police officers, lawyers, appropriate adults, independent custody visitors, and similar. So I wanted to start with a slightly different image than you might have been expecting today, because I really want us to think about looking at children in police custody with fresh eyes. So when I first went into custody suites back in 2016, I was really an alien from another planet, in the sense that I'd spent many years representing children and young people in criminal courts, magistrates courts, youth courts, Crown Court, but I was a barrister and I'd never been into the police station. So I went into that world with new eyes, really. And I have to say I was very surprised by what I found there. And it makes me wonder, we're an alien to be transplanted onto our planet today and to be taken by us into our custody suites and shown the way that children are dealt with in that setting. What would they think if we told them that we have a distinct youth justice process that focuses on preventing offending by children, that takes a child-first approach to which we're all signed up, that presumes innocence and does not punish without conviction, that we've had for 30 years overarching international conventions by which we promise to children that we will detain them only as a last resort and for the shortest appropriate period. If we told our alien that, what would they make of the custody process that they see before them? Well, this is what children told me about how they experience police custody. And in short, many of them find the experience deeply punitive. It is an experience, as you see from Michael's comment here in the top right-hand corner, and I should say these are all pseudonyms, as you will imagine. This is his description of the experience of spending time in a cell. I heard all the people kicking and banging the doors and all of the swearing and all that, and I just kept quiet and cried. And when we think about protecting the welfare of the children who come into our care in this setting, this statement of a feeling of being unsafe, a loss of security, is deeply concerning. Young people spent time in the presence of other older arrestees, often in custody suites that I visited and they told me about in their interviews. For some, that was a deeply disturbing experience, uncertain as to what contact with those adults' future further into the process they might experience. For some others and some older young people, that engagement with older arrestees took the form of a sort of normalization of offending, that they were the people who were friendlier to them in the custody suite than the officers who were looking after them. So a concerning aspect in that regard. Sadie's comment here on the left of this picture sets out really the experience of very, very many of the young people that I spoke to, that being held in a cell was horrible. They're just four walls, it's freezing, it smells, it's just not a nice place to be. And many of you will be aware that there's a prohibition on the keeping of children in cells, adult cells in the custody suite. But it's permissively framed in the legislation. As Augusta was saying, the legislation is not robust around the provision for children in custody suites, and commonly children are held in cells, much as in this cartoon image, or in kind of juvenile detention facilities, as they might be called, that are largely indistinguishable internally from an adult cell. And the experience in those cells was, for many children, an experience of disrespectful treatment, of degrading treatment. We know why. They are often stripped of all their belongings beyond their clothes. There are obviously safeguarding issues to be concerned with, but the experience from the child's perspective is, as you see in this image, really alienating and can be very distressing. Children often used animal imagery to talk about their experiences in the cell, that they were fed food that was not fit for a dog, that the blankets were like horse blankets. And the challenge is that they didn't often feel enabled or aware of, enabled to engage their rights or aware of those rights. As we see in particular with those children who spent longer periods in custody, the agony of the lack of stimulation in a custody cell, the punitive experience of that isolation, led them really to feel a kind of overwhelming sense of helplessness and loss of autonomy, which had the distinct impact of depressing their ability to engage their rights. But here in this second picture, Tom, who was one of the older young people that I spoke to, spoke movingly, and his account was not unusual amongst young people of how he'd coped or failed to cope with a lengthier period in the cell. So here he's saying it would be bad for an hour, but the length I was in there, it was terrible. I think if I had to go in now, I'd cry. I would actually cry. Zoe at the bottom of this image tells us something of what it is like to be a young person with additional vulnerabilities in that setting. She described having ADHD and having her medication delayed. And again, we know why that might occur, to ensure that no overdose can happen. But from the child's perspective, again, from their experience, She talks about bugging out, feeling in a state of sort of free fall. I was actually going crazy. I can't be in a small room for too long. And so when I was conducting my observations, the average period across all the young people that I tracked of periods in custody, this was pre-charge, was 11 hours. And that kind of fits relatively well with other assessments that we have of these detention periods. So we're talking about very lengthy periods for children. And we can see in some of these accounts just how extreme the impact can be upon them. But the major concern, well, there are two major concerns. The first is that we expect the child in this setting to participate effectively in a significant legal process that is occurring. And so I mentioned earlier the kind of depressing their ability to engage their rights. Here in this cartoon, a young person is contemplating taking up the offer of legal advice, so an absolutely key provision for children in this setting. And these two young people really raise three of the major issues that prevent the uptake of legal advice. And we know from Vicky Kemp's research, I think she's with us today, just how the low level of uptake for children of legal advice. So Carter here in the top left is talking about his doubts around the independence of the solicitor. I think they're all siding with or just working with the police. Whereas Jamal in the bottom right-hand corner is raising two issues. The first, that he doesn't understand what the purpose of a solicitor is. I don't need one. They just say everything that you could say yourself, really, refusing because they think they don't need one if they feel that they're guilty of the offence, or they think they don't need one because they feel they're innocent of the offence and have nothing to hide. And then the kind of primary issue that a solicitor might long it out, might extend that custody period. So lengthy periods in custody can have a significant effect on the uptake of legal advice, which is so key in the custody process. And we find ourselves in a situation where, in the left-hand corner here, Logan is relating a police interview experience where, having been in a cell for a long time, being desperate to get out and feeling pressurized in interview, he says, well, you might just have to lie and say, yeah, fair enough, I did do it, just to get it over with, because they just keep pressuring you. And young people often spoke about just feeling that they weren't in a position to undergo police interview because of their exhaustion and their frustration and that sense of helplessness. Commonly, young people talked about making no comment because they just didn't feel that they could be interviewed, having spent 10 hours in the cell. And when we think about what a no comment interview means in terms of engaging out of court disposals and similar, that's a very significant issue. If the custody process is about obtaining reliable evidence, then arguably lengthy periods in custody are counterproductive for that purpose. But perhaps most concerning of all is the sort of attitude that Tom, who you'll recall, was thinking about crying at the prospect of a future custody episode, that his observation here, that reflecting back on his custody experience, that he concluded that the police, they're just not nice people. I was in there for so long and they were useless when I was in there. I just don't really think they're that trustworthy. And this was not a not uncommon view amongst young people, that their treatment had been disrespectful, they hadn't felt they could engage their rights, and that they had been kept in an unjustified way or for an unjustified length of time. And the corollary of that was, as the kind of procedural justice theorists might tell us, it is a reduction in the legitimacy of the police and trust in the police as a result of those experiences. And when we think about the groups of young people who we're particularly concerned about today, children from Black and minoritized groups, and concerns around distrust of the criminal justice process that we're very concerned about in respect of that group, and the disproportionality as well. And then when we think about children who are looked after by the local authority, those very vulnerable children who might find themselves in this setting, particularly those that might find themselves in extended periods of detention, then this sort of outcome is something that we should be really seriously concerned about. And so when we think back to our alien, if they reviewed this kind of evidence of impact, what would they consider that our process comes even close to achieving any or many of those kind of statutory aims that we talked about at the beginning? A child-first approach, an approach that prevents reoffending by children and young people. Does it meet the Children Act test? Are we promoting welfare by doing these things? What strikes me as most extraordinary about the custody process is that this is the side of the youth justice process that most children, those that do encounter it, will experience, in the sense that many, many more children will spend time in custody than will ever find themselves in court, ever find themselves being sentenced for an offence. And if this harshness and punitiveness is what they experience in this early stage, then we have the process back to front, do we not? We are punishing those who are at the very beginning of the process. No one's been convicted. Many have yet to be charged. And it feels as if, taking a step back, there is much that we can learn from the experience of children in this setting to make us reevaluate what we are doing here. And perhaps this section 38(6) of PACE protection is the most important of all. It's one of the few statutory protections that children have in this setting. And if we can't manage that, if we can't break down that period and remove them from custody, then we really need to seriously consider how we are resourcing, what we are doing with children in the police station. Next month, it will be 50 years since 3 teenagers were arrested and detained in Catford for the murder of Maxwell Comfey. And that their conviction and the subsequent overturning of their conviction triggered the Royal Commission on Criminal Procedure, which led then to the Police and Criminal Evidence Act. So children in police custody has been at the heart of criminal justice reform in this area. I really applaud and commend Just for Kids' recommendations to you. And I really hope that we can, the more people who work in this area and think about this area, we can promote some change in this regard. And on that final note, before I outstay my welcome, Chris Barth from the National Appropriate Adult Network, who I know is on the webinar today, and I have been working on an animation for family members acting as appropriate adults in police custody, as a sort of information video for those who are unfamiliar with the role, to provide them with some basic understanding of what that key role is all about. So the link is here it's a free video setting out that information. I'll post it also in the chat. So do make contact with us if you are interested in this video, and it is free for use wherever you are. So thanks very much for your time. I'm going to stop sharing my screen.
Thank you very much, Miranda, for that really kind of powerful presentation that kind of really gets across the impact on children and why it's so important to kind of look at this issue. Really, really important to ensure that the experiences of children are really at the heart of this debate, because it's obviously them which is impacted the most, and it's those we should be listening to the most. So next we are going to hear from Jacqui Belfield-Smith, who's Head of Youth Justice Serious Violence Reduction and Targeted Youth Support Services at Stockport Council. And Jacqui is going to talk about the significant work that has taken place in partnership across Greater Manchester between the police, youth justice, children's services and the combined authority to really take action to reduce the overnight detention of children in police custody locally. So we're really welcome you, Jacqui, and really looking forward to hearing how you've been able to address this important issue. So Jacqui has significant management and leadership experience in youth justice, having worked in the field since 1999, and she's been head of youth justice, serious violence reduction and targeted youth support services for Stockport Council, which is one of the Greater Manchester authorities since 2005. So over to you, Jacqui, and I'm really looking forward to hearing about some of the positive work that you've been doing across Greater Manchester in partnership with the police.
Hiya, thanks for that introduction, Louise, and welcome to everybody on the call today. I'm in a very windy Manchester as Storm Franklin has sort of burst its way through, so I'm quite glad to be tucked up at home, to be honest. So I'm going to try and share my screen, and hopefully this works. Could people advise if you can see that? Because unfortunately I can't.
If you can just press the kind of icon which looks a bit like a book in the bottom right, it will make it a bit bigger. I'm not sure if we can see it, but we can kind of see it like you haven't put it on slideshow, if you see what I mean.
No, I'm about to put it on slideshow.
Great, okay, yeah, that's it, that's perfect.
Okay, all right, that's great. I can't see anything now except this, so okay, so let me talk to you about the work that we've been doing in Greater Manchester, and I need to say from the off that this isn't a panacea, this is just a model of how we can do things differently. We're absolutely not resting on our laurels at all. We're not in the least bit complacent about this. You know, we've worked really hard to get where we are, but we've still got some significant way to go. But just a bit of introduction. So as Louise said, that's my role. I'm also Vice Chair of the Association of Yacht Managers, which is the sort of professional body that represent heads and managers of youth justice services in England. So in Greater Manchester, we've got 10 authorities. I'm sorry if I'm telling you things you already know. So there's Bury, Bolton, Manchester, Oldham, Rochdale, Salford, Stockport, Tameside, Trafford and Wigan. It's one police force, which is Greater Manchester Police, 7 operational custody suites, and 2 additional kind of mothballed suites, and then a counter-terrorism suite as well. And we've got 1 probation area now, which is Greater Manchester Probation, and 1 mayoral administration, which is under the Greater Manchester Combined Authority. So in youth justice, we kind of take leads on behalf of the other 10 authorities, and one of my leads for Greater Manchester is children in police custody, and that's what I'll be talking to you about today. So back in 2011, Greater Manchester had one of the highest numbers of overnight detentions in the country. We were averaging about 100 children a month being held in detention, and the numbers who were being transferred under PACE were incredibly low, if not even non-existent. This was then reinforced by an Hmic inspection that was carried out in 2011. And one of the custody suites that was inspected was in Greater Manchester, and it's fair to say that it was incredibly critical of some of the aspects of practice that applied to everybody working in the custody suite, not just our police colleagues, but from youth offending services, appropriate adults. So there was, you know, there was a lot of work to do, and then this went on to inform the Hmic report, which was called Who's Looking Out for the Children. I'm happy to put the link for that in the chat after I've finished, but it's a good report, and you know, it did make us sit up and take notice. Very sadly, following that, we had 2 deaths post-custody. and one of those was taken up, as we know, by Just for Kids law, and that actually set the precedent for children up to the age of 18, so 18 and under being treated as children, because as you know, previously 17-year-olds were not treated as children. So where did we go then? So back in 2011, 2012, the decision was taken by very senior members across the 10 Greater Manchester local authorities and GMP to pull together a working group, and there was a real desire to have a root and branch look at how children were being dealt with in police custody. So initially this was with the 10 Greater Manchester Directors of Children's Services, senior officers from Greater Manchester Police, and also the 10 Greater Manchester Heads of Youth Justice Services, which is one of my positions. So that was the initial kind of look, and we really started to go through the work that we were doing. And then latterly, as we developed this work, and we also went into the mayoral administration, this then included the Greater Manchester Combined Authority through the Mayor's Office, integrated healthcare, liaison diversion services, children's services, including our out of hours and our emergency duty teams, complex safeguarding, our provider services for appropriate adults, Child Action North West, the Children's Society, who were doing a lot of work around child exploitation, and other stakeholders who were involved as relevant. So we set a number of objectives, but we wanted to keep them quite simple, really, which was we wanted to review the custody experience for children as it applied to them from children in Greater Manchester from the point of arrest through to exit from police custody. And our intention was to reduce the number of children who would unnecessarily been detained in custody, to reduce the length of time that children spent in custody, to improve the custody experience from the perspective of the child, and then ensure that national standards were being consistently applied across Greater Manchester. I think it would be fair to say that our ambition was, and still is, to not have any children in police custody. So the principles and the vision that we set out was to first and foremost engage with children. Miranda's presentation was very powerful, and it echoes a lot of the discussions that we also had with children in Greater Manchester, which was speaking to them to inform and shape our services, obviously keeping children out of custody wherever possible, challenging whether custody is proportionate. And then there was a real need to sort of affect a cultural shift, and colleagues will know, particularly those who worked in the public sector, that this is the hardest element. There's some very entrenched views, particularly people working in the public sector, and actually trying to affect a cultural shift is really hearts and mind stuff. It takes a while. We wanted to ensure that children were treated as children and not small adults. We wanted to ensure that children with specific needs and vulnerabilities were being identified, and that partners both within the custody suite and out of the custody suite, and those who were working in diversion services, were working in an integrated way, to ensure then that if we were signposting, that the support was there, and to get a consistent approach across the 10 Greater Manchester authorities in all the custody areas. And I think most importantly, to be ambitious for change and to be prepared to challenge. So it's all very difficult. It's easy to say, it's very difficult to do when you've got you've got big jobs, we're all very busy, and we've got competing priorities. But I have to say that this can only be achieved in partnership. There is no one agency that can manage this on their own. So the scope and governance for us was to look at all the aspects of police custody from the first point of contact, pre-custody, so that would be the point of arrest, in the custody suite, which looked at the booking in, the individual needs, the legal rights, in the custody cell, which looks at safeguarding and healthcare, and obviously really reflects upon some of the elements that Miranda talked about, and then the release and safe transfer from custody. So it meant reviewing our governance and oversight arrangements for children in police custody, and then we're making sure that those reports and those findings will then continue to be reported back through at a senior level to get that senior buy-in through the Greater Manchester Combined Authority, Directors of Children's Services, and of course Greater Manchester Police. So the activities that we undertook were informal interviews, and that wasn't just with children, but also looking involving our key stakeholders, journey mapping some cases, looking at what their experience was when they came into custody, and to really start to create a learning culture. We absolutely do not have all the answers. In fact, we don't have many of the answers, if I'm honest. So we really wanted to look at national guidance. We wanted to look at good practice around the country, including obviously elements that were coming out of the College of Policing, HMIC's welfare vulnerability for children in police custody. There was a whole host of elements out there that you and I can read, but it's about implementing that within the custody suite. The voice of the child was really important to us. We commissioned a piece of work through Quorum Voice, who are an independent participation body, and they did a small piece of work with children in one of the custody suite areas, and then we did some work with Bernardo's as well, because they were really looking at children who had been exploited and being able to kind of identify that risk of exploitation when a child is in the police custody after they've been arrested. Obviously data and analysis and process mapping was absolutely critical, and I would say probably the most difficult element to get, because we're looking at a number of different systems. Greater Manchester Police had a very big system change in the middle of our piece of work, where they went onto the IOPS system, and that made it difficult both to develop comparative data, but also to get accurate data. And then just to ensure that we continued with the governance and oversight, and to consult with HMIC around examples of good practice and the recommendations. And I would also include in that around the discussions that we went on to have with Just for Kids Law, who've been a fantastic source of advice for us. And we've sort of checked in with some of the work that we were doing, and obviously they've kind of listened to some of the work that we've done in terms of our practice. So how does it look now in practice? Finally, so these are just some of the things that we've done. We've developed and we continue to review our Greater Manchester PACE local authority and Greater Manchester Police protocol. In fact, we've just updated that again at the end of 2021, and that's very much a joint arrangement between the local authorities and Greater Manchester Police. We contributed to the 2017 Concordat in police custody, and one of our custody inspectors, Gail Spruce, is actually on the call today and will be joining us in the plenary session. And it would be remiss of me to say, not to say rather, that Gail has been with us on this journey right from the beginning and has been a fantastic GMP colleague, and has really shown the benefits of working in partnership. We tendered in 2017 for a Greater Manchester single provider for our appropriate adult service for children and adults, which stopped some of the delays in the custody suite, and it just meant there was a kind of one-stop shop really. They just phone one number and you get your appropriate adult, and I know that GMP and other colleagues and local authorities have found that really useful. We've got our commissioned integrated healthcare and liaison diversion operating in every custody suite. That's been commissioned through the Greater Manchester Combined Authority, and it's just going out for tender again. So that's had a massive impact in terms of the identification of healthcare within the custody suites. We've got a named senior lead in Greater Manchester for child-centred policing. I've talked about the participation work that we did, and also, through the Children's Society as well, with the work that they were doing in custody. We have done joint training for Greater Manchester Police and the local authorities together, where we train new custody sergeants as part of their induction. The 10 Greater Manchester authorities have commissioned a dedicated Section 38 PACE bed, which has been something that we're really proud of, and actually a bit disappointed as well, because it's not used as much as we would have liked. We would have expected it to be used more. So the onus is on us to make sure that we're promoting that fully. But it just shows the commitment at a local authority level to fund that PACE bed across the 10 authorities. We have really close liaison and agreements with our local Children's Secure Home, which is MOS, which is an outstanding secure children's home, to ensure that our transfer can be as short as possible, and that if a child needs to go into a secure bed, they can. We did have a child-centred custody task and finish working group, which is now finished, because I think all task and finish group should finish eventually. And now we've moved to a monthly scrutiny function, where we dip sample certain cases, and we look at those, and we sort of see what we could do better, really, and where we've done well, and celebrate the good practice, but also identify where we've not done things as well as we should have done. And when I say we, I mean everybody: local authorities, appropriate adults, Greater Manchester Police, whoever it involves. We had a shout out to the local libraries across Greater Manchester, because GMP were telling us that, you know, one of the big issues was around not having books, and so we called out to the local libraries, who inundated us with books, which we provided across all the Greater Manchester Police custody suites, and they were in a number of different languages and a number of different learning styles. And I think it's just thinking outside of the box, really, about, well, who's got this, who's got surplus materials that they'd want to give away. I mean, obviously they needed checking quite carefully, and I'm sure Gail will reflect on that, but you know, it was a good way of getting some information in there. And then finally, we've had significant reductions in the numbers of overnight detentions. We receive a monthly sheet, and if you remember, back in 2011, we had about 100, averaging 100 children being held overnight every month. And looking at the figures for December, we had 8 across the whole of Greater Manchester. And last month we had 11 children who were held in police custody. 11 too many, it's still, but it does show the journey that we've been on. But I have to say, we are absolutely not there yet. We still know there's a lot to do, but we are trying, and we're trying to do things as differently as we can. So on that note, I shall hand back over to Louise.
Thanks, Jacqui. That was really, really interesting listening to that. And it just really shows where there is that commitment to make a change, what can actually happen in reality. And I do think it's quite extraordinary to go from that number of children held overnight down to where you are now, obviously with the recognition that kind of still more work needs to be done. But nonetheless, that is a massive shift in terms of where you were back in 2011 when you started this work. So I think it's just so important to hear the practical steps that have been taken and what can actually happen where that will is there, because it can make a huge difference in terms of children and young people's lives. So it was really, really good to hear the work that's been done across Greater Manchester. So next up we have Alison Renouf, who is the manager, the London Safeguarding Children Partnership and Principal Policy and Projects Officer for Children's Services. at London councils, and she's going to be talking about some of the work that has been happening in London on this issue as part of the London Safeguarding Children's Partnership, and also the Pan-London Children and Custody group on reducing the overnight detention of children locally in London. So Alison has more than 25 years experience in the housing and social care sector, and including more than 7 years as manager and area manager, and 13 years in strategy and development roles relating to children and young people services. So clearly a wealth of experience. Alison's also a registered social worker and has been the manager of the London Safeguarding Children's Partnership for nearly 8 years. And Alison drafted the London Protocol for the provision of local authority accommodation for children held in police custody, which complements the Home Office Concordat that's been mentioned previously. So Alison, over to you, and we're really interested to hear what you have to say on this issue. Thank you.
Hi everyone. Yeah, I don't have a presentation, so I will just speak. I'm quite impressed by the dramatic drop, I mean, albeit over a number of years, in Manchester in the children held in custody. So I'll probably be in touch afterwards to see what we can learn. So the group that I support, the London group looking at children in custody, was set up in 2018 in response to the extremely bad HMIC inspection of the MPS in terms of safeguarding. It was a pretty devastating inspection report, but one of the things they criticised the police for was not insisting on the local authorities' duty to accommodate children who would otherwise be in custody. So the group was set up to look at that, and as a part of that I then worked with partners to develop the London Protocol to supplement the Concordat, and it just adds in bits around escalation policies and more around transfer and various things like that. We didn't get signatures, but it was agreed across London. So I'm interested when I heard earlier that authorities, not all authorities, have signed up to the Home Office Concordat. I kind of think in London they sort of have, because they signed up to the protocol and they go together. But anyway, I can follow up with that. So I think once we'd done the protocol, we realised that was just the beginning. And so alongside that, the police we've got really good data from the police on a regular basis, and that's really helped the work. So having said that, there are some caveats, some significant caveats around that. So I think it's around about 1,000 children a month are arrested in London, and about 100 of those are detained overnight. And we've made some progress in terms of provision of alternative accommodation for those, but it's stalled, and it's stalled at a relatively low level of around 15. Now, it's not 15 out of 100 because there's all sorts of reasons why some of those aren't, some of them don't go through to local authorities, but it's still not as it should be. It's a complicated business providing alternative accommodation in London because of the scale of the city. And in fact, when I did an analysis of it, most children are returned to family or neighbours, sometimes immediate family, and sometimes extended family. So what started off as a kind of thinking that this was all about the provision of alternative, provision like foster care. In fact, I talked to Greater Manchester about the foster care provision there, or the alternative provision there. But yeah, so it's really become much more that most of those children do get returned to family or friends. Alongside that, the group has also supported the rollout of Operation Harbinger, which is where the police contact children's social care to do a safeguarding check on the arrest of a child, which again is kind of, I think, moving towards recognising the vulnerability of these children, or a move along that way. When I said about the data that we as a safeguarding partnership, we struggle to get data. We're making, again, big improvements. I had a meeting about that today. In terms of other data, the custody data has been great. We've got it, and also crucially, obviously I distribute the anonymised version of it, but that local authorities can go to their yacht police officers and know the individual's name underneath that, so they can actually look into what happened in that specific case and iron out what happened in, if things went wrong, what went wrong. So that's really important. Otherwise you end up with people just saying, well, I don't recognise this data. And there's often, being London, there's often confusion as to which authority actually the child is from, and so those are quite helpful. But the data, it turns out, is only the data, and it took me quite a long time to realise this, of the children post-charge. So children held overnight post-charge. It doesn't include children held overnight pre-charge, which is, as I understand it, significantly higher. And of course, it intensifies that duration that a child is in custody. So if a lot of those children that are held post-charge have already been held overnight pre-charge, then that the experience is going to be much worse for the child. And it doesn't include breach of bail. Again, a very significant additional number of children that have been kept overnight in custody. So I would encourage any request to the Home Office to look at all of those children who are being detained, because certainly I wasn't aware that the ones that are covered by the PACE legislation is a much smaller subset. So we continue to send out the data. We continue to do work with local authorities to work with them to increase the number of children that are being provided with alternative accommodation. And there are some pockets of really good practice, but it's about trying to get that extended. But we're also looking at the moment at how we can get more children out of custody before on the day of charge, at least. So getting them to court. We haven't sort of drilled down to this, so it may or may not prove to be a significant issue, but the police seem to be working with a 1 o'clock, I think it's a 1 o'clock cut-off to get children to court for 3 or 4 in the afternoon. I can't remember which. Whereas I think it was for 4 o'clock, but the courts, the magistrate we have on the group was saying, well, we will take children really almost up to the wire because we really want to get them out of custody, and certainly longer. The cut-off wouldn't be till 3 or something. So there was a real big gap, and potentially if we could change that custom and practice in the police to get more children to court on the day, and the same was being said about the weekends, that there's that it's potentially the police are being too conservative in terms of how long it's going to, how much notice they need to give to get children to school, to the court rather, and CPS representatives are saying, we will make huge efforts to get them to court on the day. So we're going to have a look at that as well, and I think it's a kind of broader issue of trying to address the fact that whilst provision of alternative accommodation is really important, it's kind of loading a lot of resources at something that's already not a good thing, not a good place to be at. We really want to reduce the number of children being arrested. We want to reduce the numbers that are being held. There's lots of and that would be a far better outcome than providing them with alternative accommodation, although that's also important for those that for whom they have to be detained. We'd also done quite a lot of work, I should also say, with the police around reducing the amount of requests for secure accommodation. London is particularly ill-served for secure accommodation anyway. I can't remember the distance from the nearest secure accommodation, but it's a long way. And although there's work being done at the moment to try and procure secure accommodation within London, that's a long-term project. It's all sorts of issues around it, not least of which is planning permission. But also I think thinking that it's already been mentioned that the threshold for secure is very rarely met, but it's much more commonly requested. So there has been progress on that, and there's been a significant reduction in requests for secure accommodation. But I think, again, even given that a lot of these children, they aren't going to kind of specialist care, they're going back to family, they're going back to friends, they're going back to neighbours. Why, again, I think it raises the question as to why they weren't released, they weren't bailed, rather than held overnight. So that's where I realised I didn't say that the group is chaired, or I don't think I did, chaired by a Director of Children's Services. There's reps from youth offending, children's social care, obviously the custody team, British Transport Police, because they've got a custody unit in London, City of London Police, although they minimal children, and yeah, and it's been really quite an active group. Oh, and the other thing is we also look at support services. There's liaison and diversion. We have them across London as well, but also there's been specific commissioned services that have gone into various custody suites, and there's over 20 custody suites in London, and there's just a sense of trying to keep an eye on all of these different support services and whether or not we can develop a kind of minimum offer across all of the custody suites, because at the moment they tend to be kind of one-off pots of funding. So what can we learn, and what really needs to be embedded as an offer to children? But again, I think looking at really wanting to focus on reducing the numbers coming into custody and the numbers staying as well. So I'll leave it there.
Great, thanks very much, Alison. Really great to hear some positive work happening in London, and two things really struck me actually that you mentioned. The first was about the data and ensuring we kind of have the sort of the clear picture of what exactly is happening, both for post-charge but also pre-charge, as you recognised, as where the greater number of children held for long periods of time happens. That's certainly something that we've really struggled with when carrying out this project, in terms of getting hold of really granular data so we can really understand exactly what's happening. And I think in terms of sort of accountability and scrutiny, having that right data is kind of really crucial. And the second thing that really struck me was around the importance of not losing sight of the importance of the upstream activities in terms of reducing the number of children coming into custody in the first place, looking at things that we can do early on in the process and not just focusing on how much secure accommodation we have, and thinking that all the answers lay in that. Although it's important for the small numbers of children that need it, there's lots of other sort of practical things we can do before it may get to that point. And so it's need not to kind of focus our attention just on that one thing, which I think in the past there has been a lot of focus on Section 38 beds, which is obviously crucial, but it's looking at the kind of the impact on all children and not just those who are covered under PACE. So thanks very much. That was really interesting and great to hear some of those the points made. So we've got some time for question and answers from our panel members, and I also wanted to welcome Inspector Gail Spruce from Greater Manchester Police. Hi, Gail.
Hi.
So Gail's worked very closely with Jacqui on the work she was talking about, and is going to be joining us for the question and answer session as well. So like I mentioned at the beginning of the webinar, that we're using the Q&A function. So if you put your questions in there, if you could say your name and your organisation, and if your question is directed at a particular person, then that would be helpful. If it's for everybody, then obviously you don't need to. We've got a few already I can see, so I'm just gonna pull those up. So first up, we've got one from my colleague, Jennifer Twight, and it's actually directed at Alison. So Jen asks, is there any work discussing with the police about the time they arrest children? We see lots of children arrested in the evening, when then it will always necessitate an overnight stay.
We haven't looked at that. No. I think I thought when I started doing it that they were all being arrested quite late, and that's why they were being held overnight. And really, did it make much odds? What was the point in taking a child out of police custody at 11 o'clock at night and then driving them 2 hours across London to sleep for 4 hours to get up at, you know, whatever. But I think what's emerged is that it's not necessarily the case that children, I haven't got data on time of arrest, but I think the problem is not just this very practical issue of you know, if you're arrested quite late, then it all becomes extremely difficult to work out moving you, particularly across the London city the size of London. So, but that would be interesting, but we haven't had that data.
Jacqui and Gail, I wondered if it was something that you looked at all in the work in terms of reducing numbers of children held overnight.
I think it's definitely one for Gail.
To be honest, I don't think we've got a problem with the time. What we tend to see in GMP custody is dynamic arrests that are either required or not. Certainly in terms of out of hours, and we have a function that triages arrests, which gives us that additional opportunity to sort of challenge, does this person need to come in now, or can it come in a week on Saturday, pre-arranged with an appropriate adult? So that's really useful for that purpose. But I genuinely believe over time that this message has simply filtered down, that you arrest a child inappropriately for a pre-planned issue, then you will be yourself tied up for excessive amount of time when you really wanted to go home, aside from the impact on other agencies and the detainee themselves. So I genuinely say we don't tend to have a problem with it. If it's dynamic, as I say, it comes into custody and it's serious enough, it is what it is, and it is whatever time it is. And certainly our remand figures would bear that out in terms of the 8, the 11 that Jacqui talks about. All of those will probably have been arrested late at night for dynamic, serious issues. But I've certainly been around long enough with Jacqui doing this work to remember a time when those 13-year-old shoplifters were coming in at silly hours because that, for whatever reason, suited somebody else. But no, I think we've evolved. I couldn't say we've had a proactive strategy, but it's definitely evolved in a good way.
And when we look at the children that are held overnight, even if it, you know, the 8 or the 11, you know, the gravity of those offences are always very high, and because the gravity, then obviously it takes such a long time in terms of kind of, as you know, anyone who's been in the custody suite, in terms of the investigation and just getting everybody where they need to be. And the conversations that we've had and we continue to have is, how early in the day can you start making those arrangements for transferring that child out, be it a secure bed or a safe bed? Because, you know, we try to be clear, a PACE bed is not something with lights over it that says PACE. You know, we do have a Section 38 bed, but it could just as much be going back to Auntie Joan's house. And I think it's about people being quite proactive early on about trying to establish with colleagues in children's services out of hours, you know, what availability there will be on the likelihood that at some point during the evening or during the course of that investigation, that child's going to need to find somewhere. Because I think what we were finding, Gail, and I think it'd be fair, a lot of it was being left to the last minute, and then there was a bit of a flurry, and then we just ran out of time. And under the practicability PACE guidance, it just meant that if it had gone midnight, we weren't able to transfer those children. So I think, you know, there's no simple answer to it, but I think it's just the scrutiny function helps, because we look at those individual cases and think, well, what went wrong there or what went right there, and that's how we learn. I think that would be fair enough to say on behalf of Greater Manchester, but on behalf of any scrutiny function, to be fair.
Yeah, just to quickly throw in there on the back of what Jacqui has said and going back to data that was alluded to earlier and quality data and the need for quality data. When we are looking at our remand cases, we are looking at the time the child was charged. We are looking at the time the local authority was contacted. We're looking at the time the local authority responded to the custody office. So it's transparent about where we've fallen down, which absolutely helps us go forward.
Could I just ask something actually?
Yeah,
just
of course, yeah.
for Greater Manchester, that how many your data of the sort of less than 10 is post-charge? Is there a significant number that are held pre-charge, and then there's the breach of bail as well? Is that something, I think our breach of bail and our pre-charge detentions are much higher than our post-charge detentions.
Gail can pick up on the latter point. Average number of children being arrested during the month is about 250 across Greater Manchester. Gail, do you want to pick up the other matters?
Yeah, so if we average about 250 arrests, so that's all arrests, so the PACE and the non-PACE, go into the ones that we remand, which is, let's say maybe it's 10, so it's it seems kind of far less than the Met rate for remands, which appeared to be about 10%. I think ours will be about 5% for those refused bail. Gosh, I've forgotten now what the question was. But yeah, in terms of all of those arrests, we don't interrogate each of those because there's so many of them, but I certainly do a dip sample of all arrests to look at various categories. So I will be looking at those held overnight. Why were they held overnight? And again, this goes back to data, doesn't it? I prepare that data, a lot of it for myself, to feed back to my own colleagues. And I come back to it the day after, even I sometimes am asking myself what I meant by the heading that I put on a spreadsheet yesterday. So data has to be so specific, doesn't it, to it's meaningful to everybody. But yeah, so I will look at overnight detentions, and reasons for that might vary between there wasn't an appropriate adult, that comes up quite a lot. It wasn't appropriate to do an interview because the child was distressed. So on the face of it, when you look at something like all of these young people held overnight, that's why you've really got to drill down as to the reasons why that is. Why has somebody been held without an interview? Well, actually, there's 5 or 6 different reasons, some of which are absolutely valid and some of which are clearly not and need challenging, but it's that level of detail that we need to get to.
Yeah, thank you.
Yep, thanks. Yeah, I completely agree with that. We've got a question from Havana from MOPAC, which is the Mayor's Office for Policing and Crime in London. So she's asking if we have any data on the number of children held overnight who are children in care. So I know this was not something that we actually looked at in our freedom of information request, because we were focusing more on age and ethnicity. But she was saying that they have completed a very small dip sample of custody records and found that 3 out of 10 children were children in care. So I wondered if it reflects or people can relate to that in terms of the research that others might have done. I don't know if Miranda, if you looked at, if you covered children in care, particularly in your research that you did, and how often that was the factor.
My sample is very small, so it would be difficult to provide anything generalisable, but it was striking that those who spent longer periods in custody were commonly children who were looked after or in care in some shape or form. So yes, significantly overrepresented, but I wouldn't pretend I've got generalisable figures.
If I may come in as well,
Yeah, of course.
measure that, but I'm really interested in doing so. So certainly with that remand data that I supply to the authorities, Jacqui, I think it would be interesting to simply have an extra column that determines those that are looked after purely from a disproportionality point of view. We need to understand what those figures mean. And like when I'm doing a dip sample of the wider arrested population, that's easily something I can look at to see what it tells us. But historically, we wouldn't have anything area.
I think we keep adding columns to our sheet, I have to say. So we obviously measure ethnicity, the area, we know the arresting officer, we know the custody suite, we know which local authority dealt, where the child was from, who dealt with it, etc., etc. So yeah, I mean, it's interesting because that was the question from MOPAC, but we've actually produced some data just today for our combined authority through GMCA on looked after children within the youth justice system. So, you know, with our children looked after numbers, we know they're disproportionately represented within youth justice. So every single one of those children that we're looking at, obviously we know the information about that, and we know that children across Greater Manchester are disproportionately represented, which is no great surprise, but we've got the data to back that up. So yeah, we can look at that as well, Gail, that's great.
Great, thank you. I'm just aware of the time, so I think we might only have time for one or two quick questions. So this is a question from Bill Turner. Sorry, Bill, I'm not sure what organisation you're from, but he was interested, so I think Augusta, this is actually one for you, in relation to our recommendations, the ones you thought might be most appropriate in terms of some immediate change in the system, which could be achievable by practitioners working in it, given some of the challenges in terms of the longer time system-wide change in relation to sort of the actual legal changes that we were seeking, just to highlight some of the more the other recommendations aimed at the police specifically, if you want to come in and highlight those ones.
Hi, thank you. Yeah, absolutely. I think one of the key messages and one of the things that we really wanted to communicate with our briefing and recommendation is that there are obviously, and that has been the focus of my presentation especially, there are obviously some top level actions for the government and different agencies to take. However, within that, there are a number of actions that can be taken on a day-to-day basis. Some of them are more at a police level, but some of them are actually very strictly relevant to practitioner and include things like, and some of it is actually very basic. I mean, it's easy for me to say I'm not the person who is in custody, but include clear communication. Just having one of the things we've noticed is forces that have quite good set and well-identified communication pathways and how to challenge refusal and such things tend to have fewer children held in custody. And we've seen a very high number with forces and local authorities that don't have a protocol in place, so they don't actually have something for practitioners to actually refer to when they need additional guidance. And then some of the other recommendations are quite specific to custody officers and just practices in terms of when a child initially comes to custody. So we know that some police forces are now advocating for an opt-out system. And again, this is not a step for the individual police officer to take, but it's definitely a step that can be taken at police force level. But some of, in that context, one of the things that can be done is making as prompt and immediate contact, for example, with appropriate adults and with colleagues from social services as well as solicitor as soon as we know that a child is coming to custody, and just like so those are some of the ones I can think of on a more practical level for police staff. And similarly, whilst for local authority staff, some of the things I can think of include ultimately the decision is for the type of accommodation that is requested is for the police to make, but if there is a pattern or if something is noticed, it then falls on the individual local authority staff to make sure that that is being challenged. Another thing that we've noticed that tends to really work well is joint training. So one of the recommendations we've put forward is for there to be more training, but we felt that when this is jointly done between the local authority and custody staff, so the EDT, the emergency duty team and custody staff, this tends to work out quite well. So that can be one immediate takeaway step. Thank you.
Great, thanks, Augusta. And Bill, just to say, our briefing is available, the link where you can see all the recommendations. There's a link to it. I think it's further up the chat. You should be able to find it then. So I'm just aware that we've reached 4 o'clock, so we're kind of due to kind of wrap up at this time. So I just wanted to thank all the attendees for spending the time this afternoon on this important issue, and also to our speakers, Alison, Jacqui, Miranda, and also Gail for joining us for the Q&As, and also Augusta for her work on the project and doing the presentation earlier on today. And I think the key sort of takeaway is there's, you know, it's still a significant issue, and there's still a lot of work that needs to be done. And I think what Miranda talked about in her presentation in terms of the real key impacts on children is something we really need to kind of hold at the forefront of our minds to remind ourselves why you know, we do need to take steps to address this important issue. But I think there is kind of room for optimism, and I think hearing about the work that is happening in both London and in Manchester is really good to hear, and just shows where there is that political will, where you manage to achieve that culture change, which might be difficult to get initially, but once you get that, then you can really make a massive difference in terms of addressing this issue and significantly reducing the number of children held overnight in police detention. So I think we can end on a note of optimism that you know, we can make a difference, and we can really address this important issue. So thanks very much everyone for joining us. Do take a look at our briefing. The recording, if you want to share it with colleagues that maybe couldn't make it today, will be available and will be circulated along with all the slides that we heard today. So thanks ever so much for joining us today, and we look forward to working together with you to basically reduce the numbers of children held overnight in police detention. Thank you.
Thank you.